My name is Bryn Froman, and I will be giving the following speech by Barbara Charline Jordan on the Articles of Impeachment. Earlier today, we heard the beginning of the preamble to the Constitution of the United States, We the People. It is a very eloquent beginning, but when that document was completed on the 17th of September in 1787, I was not included in that We the People. I felt somehow for many years that George Washington and Alexander Hamilton had just left me out by mistake, but through the process of amendment, interpretation, and court decision, I have finally been included in We the People. Today, I am an inquisitor. A hyperbole would not be fictional. It would not overstate the solemnness I feel right now. My faith in the Constitution is whole. It is complete. It is total. And I am not going to sit here and be an idle spectator to the diminution, the subversion, the destruction of the Constitution. Who can so properly be the inquisitors for the nation as the representatives of the nation themselves? The subject of its jurisdiction are those offenses which proceed from the misconduct of public men. And that's what we're talking about. In other words, the jurisdiction comes from the abuse or violation of some public trust. It is wrong, I suggest. It is a misreading of the Constitution for any member here to assert that for a member to vote for an article of impeachment means that member must be convinced the president should be removed from office. The Constitution doesn't say that. The powers relating to impeachment are an essential check in the hands of the body of the legislature against and upon the encroachments of the executive. The division between the two branches of the legislature, the House and the Senate, assigning to the one the right to accuse and to the other the right to judge, the framers of the Constitution were very astute. They did not make the accusers and the judges the same person. We know the nature of impeachment. We've been talking about it a while now. It is chiefly designed for the president and his high ministers to somehow be called into account. It is designed to bridle the executive if he engages in excesses. It is designed as a method of national inquest into the conduct of public men. The framers confided into Congress the power, if needed be, to remove the president in order to strike a delicate balance between the president swollen with power and grown tyrannical and preservation of the independence of the executive. The nature of impeachment, a narrowly channeled exception to the separation of powers maxim. The Federal Convention of 1787 said that. It limited impeachment to high crimes and misdemeanors, and discounted and opposed the term maladministration. It is to be used only for great misdemeanors, so it was said in the North Carolina Ratification Convention. And in the Virginia Ratification Convention, we don't need to trust our liberty to a particular branch. We need one branch to check the other. No one need be afraid, the North Carolina Ratification Convention. No one need be afraid that officers who commit oppression will pass with immunity. Prosecutions of impeachment will seldom fail to agitate the passions of the whole community, said Hamilton in the Federalist Papers, number 65. We divide into parties more or less friendly or inimical to the accused. I do not mean political parties in that sense. The drawing of political lines goes to the motivation behind impeachment, but impeachment must proceed within the confines of the constitutional term high crimes and misdemeanors. Of the impeachment process, it was Woodrow Wilson who said that nothing short of the grossest offenses against plain law of the land will suffice to give them speed and effectiveness. Indignation so great as to overgrow party interest may secure a conviction, but nothing else can. Common sense would be revolted if we engaged upon this process for petty reasons. Congress has a lot to do. Appropriations, tax reform, health insurance, campaign finance reform, housing, environmental protection, energy sufficiency, mass transportation. Pettiness cannot be allowed to stand in the face of such overwhelming problems. So today, we are not being petty. We are trying to be big because the task we have before us is a big one. This morning, in a discussion of the evidence, we were told that the evidence which purports to support the allegations of misuse of the CIA by the president is thin. We're told that evidence is insufficient. What that recital of evidence this morning did not include is what the president did know on June the 23rd, 1972. The president did know it was Republican money, that it was money from the Committee for the Re-election of the President, which was found in the possession of one of the burglars arrested on June the 17th. What the president did know on the 23rd of June was the prior activities of E. Howard Hunt, which included his participation in the break-in of Daniel Ellsberg's psychiatrist, which included Howard Hunt's participation in the Dita Beard ITT affair, which included Howard Hunt's fabrication of cables designed to discredit the Kennedy administration. We were further cautioned today that perhaps these proceedings ought to be delayed because certainly there would be new evidence forthcoming from the President of the United States. There has not even been an obfuscated indication that this committee would receive any additional materials from the President. The committee subpoena is outstanding, and if the President wants to supply that material, the committee sits here. The fact is that on yesterday, the American people waited with great anxiety for 8 hours, not knowing whether their President would obey an order of the Supreme Court of the United States. At this point, I would like to juxtapose a few of the impeachment criteria with some of the actions the President has engaged in. Impeachment criteria. James Madison from the Virginia Ratification Convention. If the President be connected in any suspicious manner with any person, and there be grounds to believe that he will shelter him, he may be impeached. James Madison, again at the Constitutional Convention. A President is impeachable if he attempts to subvert the Constitution. The Constitution charges the President with the task of taking care that the laws be faithfully executed, and yet the President has counseled his aides to commit perjury, willfully disregarding the secrecy of grand jury proceedings, concealed surreptitious entry, attempted to compromise a federal judge while publicly displaying his cooperation with the processes of criminal justice. A President is impeachable if he attempts to subvert the Constitution. If the impeachment provision in the Constitution of the United States will not reach offenses charged here, then perhaps that 18th century Constitution should be abandoned to a 20th century paper shredder. Has the President committed offenses and planned and directed and acquiesced in a course of conduct with which the Constitution will not tolerate? That's the question. We know that. We know the question. We should now forthwith proceed to answer the question. It is reason and not passion which must guide our deliberations, guide our debate, and guide our decision.